Welcome to Regulatory Ramblings. Our podcast today is brought to you by the University of Hong Kong's RegTech Lab, the HKU Standard Chartered Foundation's FinTech Academy, the Asia Global Institute, and the HKU edX Professional Certificate in FinTech, with support from the university's Faculty of Law. Our guest today is Hong Kong-based Jonathan Crompton, a partner in the law firm of Reynolds, Porter and Chamberlain, or more succinctly known as the RPC law firm. There, he helps companies and individuals navigate complex cross-border disputes and investigations involving their Asian operations. He specializes in commercial matters, financial services, and technology-related disputes and cyber incidents. As the lead of RPC's Resecure Cyber Incident Response Service in Asia, Jonathan advises local and multinational clients on cyber attacks, data privacy, and law enforcement investigations, as well as helping clients across the globe recover money transferred to Hong Kong bank accounts as a result of cyber and other frauds. He also helps clients in the retail industry with technology and distribution-related problems. Jonathan advises on all forms of disputes, including litigation before national courts and arbitral tribunals operating under various rules, in particular the HKIAC, ICC, and UNICITRAL, on investigations by regulators, notably financial services regulators such as Hong Kong's very own Securities and Futures Commission. His clients include senior individuals, asset managers, and leading multinational corporations and brands. As a result of RPC's predominantly conflict-free model for financial services disputes, Jonathan represents senior individuals and companies in claims brought by or against leading banks where other firms are all too often unable to act. He is also a founding member of the Hong Kong chapter of CFAAR, CFAAR, the Crypto Fraud and Asset Recovery Network. It's the first globalization of its kind for such professionals, and the London chapter was launched in 2021, with the Hong Kong chapter following in September of 2022. And with that, Jonathan, thank you for joining us.
Thanks very much, Ajay.
So tell us a little bit about yourself. Where are you from? Where did you grow up? How did you end up in the legal profession? And, more contemporarily, how did you end up as, a prominent lawyer certainly in this town in the field of virtual assets?
So I was born in England into a military family. My dad was a radio technician in the Royal Air Force, and I moved to Cyprus when I was 3 months old. So I grew up in Cyprus, Scotland, and Gibraltar before landing in southeast England at the age of 7. I went to a state grammar school, followed by university in London, where I studied LLB law with European legal studies, and then had 1 year at Uppsala University in Sweden. I trained at a magic circle in London and did seats in general banking, competition, litigation, as a judicial assistant to Mr. Justice David Richards of the High Court in London, and in the corporate department in Luxembourg, which was a French-speaking office, and then qualified into the litigation department in March 2006. It was a very finance-focused law firm, so I did a lot of finance disputes work there, and did a secondment to the equity derivatives and hybrid products team of the Global Investment Bank in London. And then in 2008, November 2008, during the global financial crisis, I moved to Hong Kong for 2 years, as is quite often the case, and 15 years later, I am still here. So that's the very quick overview. But to the more specific questions, how did you end up in the legal profession? And then how did you end up as a lawyer in the field of virtual assets? A bit about myself. So I like performing, I like arguing, and I like winning. And I did briefly consider going into the military because my father was in the Air Force. But I considered much more considerably whether I would change school and go and study performing arts, because I did a lot of amateur dramatics when I was growing up. I thought very hard about whether I would do a performing arts A-level instead of more traditional A-levels. but decided to stay at school, partly because I wanted my career to be driven by how hard I worked and my ability, rather than whether I fit the picture of what a specific director wanted at a time. But I was interested in law, I think, as a lot of people are, because I watched a television program. I think you can tell the age of people depending on which TV program they say attracted them to the law. For quite a long time, it was Rumpole of the Bailey, then LA Law, which was the one that got me very interested in the glamour of the law. Then Ally McBeal, and then Suits. I don't know what current one is, maybe the Lincoln Lawyer, but I was particularly attracted to the glamour of the law by watching LA Law. And I decided to stay and do traditional A levels and then study law at university, and stayed on that path. And each couple of years, I just checked that was what I really wanted to do at the time, and decided to stick with it. It's definitely not a profession that you should fall into by default or just because you're on the conveyor belt. But I think as long as you're checking yourself every year or every 2 years, this is what you want to be doing. Although it's a very hard profession, I think it's very rewarding. And the last question of how did you end up as a lawyer in the field of virtual assets? Well, cryptocurrencies and virtual assets didn't actually exist when I qualified or when I moved to Hong Kong even. The Satoshi Nakamoto white paper on Bitcoin was only released in 2009. I've always had an interest in technology, but I was doing a lot of financial disputes, financial regulatory investigations. And it really became quite a natural progression as virtual assets started integrating into traditional finance for lawyers in the traditional finance field to take up and advise on how the regulators would see cryptocurrencies and virtual assets being regulated. It's really because I was quite open and decided to apply that traditional legal experience to the new area that I got very heavily involved in the fraud side of cryptocurrencies, because when you're helping a client try and recover money through a crypto fraud, it's very similar to any other type of fraud that they're engaged, that they become the victim of. And you'll see a lot of the very prominent lawyers in Hong Kong, and actually the non-lawyers who are involved in virtual assets they have a more traditional background. They do more traditional finance, or they've come out of traditional finance houses or law firms that focus on traditional finance houses, and they're then helping clients in this new industry understand how the laws and regulations will be applied.
It's interesting to hear you say that the law shouldn't be a profession you fall into, but and by the way, in terms of your the pop cultural influences that may have nudged you in the direction of the legal profession, I see we're both children of the 80s in the sense that we had some of the same influences, Rumpole of the Old Bailey and LA Law. And by the time Ally McBeal had come around, I was already in college. Ally McBeal never really did it for me, though I have to say the last chance to save that show was probably Robert Downey Jr. Then he had his, he fell off the cart. He had his issues in the late 90s and came back stronger than ever as Tony Stark in the Marvel Comics universe. But something else you said that piqued my curiosity, and this really, believe it or not, crystallized for me last night when I read a post, was that and this is a question that's been on my mind for a while. All too often, you see non-technically trained lawyers, often from the dispute resolution practice, and this is typically how it goes. They have a client, there's a dispute, it just happens to be in technology sphere, it happens to implicate technology issue, and that's how they get drawn in. But oftentimes, I have to query, for example, in the US, you have the patent bar, right? And to sit for that, you have to have a degree, an undergraduate degree or postgraduate degree in a STEM field, either engineering or a hard science. All too often in this space, you see lawyers with non-technical backgrounds advising on technology-related stuff. I mean, okay, you might say they're only dealing with the legal aspects, but then it begs the question, how much of a technology background do they need to have? I mean, if you were someone like a friend of mine, Ron Yu, who's an adjunct professor of law in this town, a client may have more confidence in his background because he saw it from both. He's one of the rare people that's worked on both the software and the hardware side during his time at IBM. Then he got his law degree, and now he's an adjunct professor of patent law and IP law. I mean, and something, a LinkedIn post that caught my eye last night was by Hugo Hoyland, who's Chief Strategy Officer at Asset Reality, and it's entitled The Illusion of Crypto Expertise. And he says, I quickly want to read this passage, "I struggle with the term expert in crypto. In last Sunday's episode of Special Ops Crime Squad UK, I was asked how I wanted to be introduced when discussing Operation Solana, fantastic Gwent police operation into crypto money laundering linked to drug trafficking. I couldn't bring myself to say expert, opting instead for digital asset investigation specialist. Here's why. In the ever-evolving world of digital assets, the notion of a crypto expert has become a sought-after accolade. Just look at how many training courses promise to make you just that. Having now spent a few good years in the sector, I think we are sending the wrong message by encouraging others to try and reach what I see as a wholly unattainable title. The rapid pace of innovation in the digital asset space means there are simply too many protocols, asset types, functions, smart contract structures, and centralized and decentralized market participants for any individual to truly master. Digital assets are multifaceted, a blend of technology, economics, finance, law, and every facet presents its own challenges and nuances that make it impossible for a single person to possess comprehensive expertise in all those areas. Even those who specialize in certain aspects must continually adapt to its evolving nature. Complexity only intensifies as you narrow your focus to just investigative use cases. Investigations into digital assets require a diverse skill set. Not only do you need to understand the fundamentals of blockchain and distributed ledger technologies, but you also need to be able to leverage a broad range of information sources, open source, public records, internet infrastructure, computer forensics, and human sources, and apply these skills to specific and complex legal frameworks and regulations. Your thoughts?
I mean, I agree with Hugo on the idea that there are too many courses out there that promise to make you an expert in cryptocurrency generally.
And it's an emerging field, so people could be very easily led to, when we're early in root stage of this field. So, yeah, if you've got someone who's telling you, someone who knows more than you could be inclined to think that person's an expert.
Yes, and that's actually why the Law Society of Hong Kong doesn't like people calling themselves experts. It's something that they frown upon in terms of marketing of our abilities in the profession. What I would say is that it is a new field, like you say, and I think it's great that there are universities in Hong Kong that are leading the way on blockchain research and blockchain teaching, and that will then provide both Hong Kong and the region and the world with a lot of people who have been taught about how blockchain works in practice. I know that you've had Don Day on this before, and he administers a course at one of the universities, an MSc FinTech course, and he brings in people, and I've taught on that as well.
Yeah, Chinese.
Exactly, and we try to make virtual assets and fintech something that is real. And the class that I teach there is about how to talk with lawyers, and that is really what I would say is that anybody getting into this profession needs to understand what their skill set is. I would not put myself out there as saying that I'm an expert in licensing. I wouldn't say that we can do licensing work, and clients have asked us to do that. That's fine. But I know what my sweet spot is. And my sweet spot is the litigious side of virtual assets. We have a lot of people in our firm who can do the non-litigious side, and I'm very happy to introduce people to them. But I know that my sweet spot is the experience that I have advising clients on in investigations by the regulators in trying to recover money from Ponzi schemes. And if you apply that skill, you know what that skill is. You're not trying to be all things to all clients in the digital asset sphere, which really is an entire kind of parallel universe of finance that is slowly colliding with traditional finance. And if you go on to look at what Hugo also says, he says, with investigation, what makes you valuable to your sector is your ability to look at something you haven't come across before and leverage your knowledge of fundamentals and apply a rigorous methodology to understand the activity. Explain what you're seeing, what you can be sure of, and what you're unclear about to others, and then work the problem together by leveraging each other's knowledge to paint a more holistic picture. And that's very much how I approach things, is that I have a mind that is open to understanding how different technologies work. I grew up with various different personal computers and following my dad and trying to understand how technology worked. I didn't go and get an engineering degree or a chemistry degree, so I definitely wouldn't be doing patent work. But what I do is I take what I have a lot of experience in, and then ask the questions of the true experts who are my clients, and be open to understanding how that works and work the problem together. So I think if you adopt an approach where you know what you're good at and don't try to be all things to all people, you will then have non-technically trained lawyers being able to advise technical companies on how, for example, the regulators are going to regulate a new asset class.
Yeah, I mean, I guess the perennial question is how tech set, if we have to distill it down to one chestnut, for people to retain, I'd say the perennial question is how tech savvy do lawyers need to be when advising on technical matters, and I guess it's going to differ case from case to case. Now, what you were saying about the Law Society's position, I think that's how it is in the States as well. That if you look at the model codes of professional conduct in all 50 states, or it's modeled on the model rules of professional conduct in the American Bar Association, you are strongly discouraged from calling yourself an expert because it raises undue expectations on the part of the client. That's why people are more apt to say, my practice centers on, or my practice tends to be specialized in, X, Y, and Z, and that's more realistic. Though I think even using the term specialist can get you into trouble. So people need to be cautious, because how we describe ourselves does give rise to certain expectations on the part of the clients and the public at large. But there is a commercial aspect to it that's rather distasteful, but that I do see in Asia, which is people fronting expertise, people repackaging the knowledge and experiences of others. And just because they speak well, just because they present well, they know how to do solid marketing, that you see someone who's more of a P.T. Barnum or an Ogilvy, the brains behind the PR firm, someone of that ilk succeeding rather than someone who's more of an Einstein, if that analogy comes through. I'm just curious about that, because it quickly becomes apparent who's got the knowledge and who doesn't. And those I find that perhaps are lacking in that knowledge. They have the biggest platform, and people, society at large, pays attention to them. Whereas the ones that are tech savvy are just, getting on with it, doing the work, serving their clients. I want to come to your caseload, though. I mean, you mentioned that you've seen more cases in the areas of digital assets, digital contracts, and cybersecurity come your way. Without getting too specific into the particulars of individual clients' cases, could you describe any common themes, trends, patterns of interaction, methodologies that you're seeing?
Yeah, I'll start with the crypto fraud, and really the if you look at the methodologies, they're very similar to any normal confidence trick. So the victim is contacted out of the blue by a fraudster, usually with a fairly innocuous message like "Hi, Dad," or something similar, or they put themselves out on dating platforms to be contacted. That then leads to a conversation, and over the course of a few weeks, the fraudster will then build the confidence and build a rapport with the victim, the mark, at that point. And there'll always be a statement somewhere in there that the con artist can help the victim. And ultimately, that will lead to a transfer of assets. And I'll get on to more specifics in a bit. But having transferred assets, there's then further bluff about how much those assets have become through an investment scheme. And when the victim tries to look at getting the assets back, that then leads to the transfer of, or the request to transfer more assets. So in terms of specifics, for example, there's quite a common con that involves investing in cryptocurrency and investing in effectively a fake cryptocurrency platform and showing the value of the investment going up and up, and then encouraging further investment, saying that the con artist will co-invest as long as the victim can provide X amount, maybe 10, 20 million Hong Kong dollars worth, then that would be co-invested with a similar amount by the fraudster. And when the fraudster tries to get some money out, they're given a small amount. So they believe that it's safe because they were able to get a token amount back. But that's really just their own money, and it's a small fraction of their own money. And when they then subsequently ask to withdraw more money, they get told that they need to pay a tax payment. And they need to pay a tax payment to the cryptocurrency platform, which a legitimate cryptocurrency platform would not do because they don't pay tax on behalf of customers. So that leads to more frustration, and in a sign of desperation to get their money back, the victim will generally borrow money off friends and family to make this tax payment in the hope that it will then lead to the return of all of their assets. But what they're really doing is just transferring away more money. And we see that scheme a lot, an awful lot. And it's people all over the world, North America, South America, South Asia. And it's with different fraudsters and with different platforms, but it's quite a common ruse. And it tracks actually what you would see in a traditional Ponzi scheme as well. The question then is, how do you help them get the money back? And the difficulty with cryptocurrencies is that they move so quickly that that you need to engage in a tracing exercise. Cryptocurrencies, unless it's a privacy coin like Monero, then cryptocurrencies are generally transparent. So you can trace the blockchain, There are some very good blockchain tracing companies out there that can give you enough information to say where the assets have landed, and then try and get those assets back. The difficulty with that is that if you want to pursue more traditional legal methods like getting an injunction, they're very expensive. And like most victims of fraud, the victims don't have any money to pursue that.
That's true. And then it's also a matter of getting a foreign court to oblige under principles of comity.
Absolutely. Now we've worked on some cases where the victims have done a very good job of getting disclosure orders from foreign courts, and they've then gone to legitimate cryptocurrency exchanges and got disclosure, but they simply don't have the assets to pursue a full legal strategy in Hong Kong where they think the fraudsters are. So then they have to rely on the police and the goodwill of the police.
It's stories like this that I would say that is why a large chunk of the investing public, certainly in this town, is not so old. On crypto. That part of it is generational divide, of course. But yeah, these issues can arise with investments of any medium, of any instrument. But crypto has a particularly bad rap, and again, stories like this don't do much to instill confidence in the market.
And that's absolutely right, AJ. We've helped victims of more traditional frauds or frauds that have been carried out as a telephone scam where the victim's been encouraged to download an app onto their phone, which has essentially scraped their banking app credentials. They've taken money out of their account. It's not a crypto fraud. It has a tech aspect to it. The difficulty with virtual assets is that they move so quickly that it can be very hard to trace in a more traditional way. And that, I think, is why the regulators in Hong Kong are taking a fairly conservative approach to their regulation of virtual assets. But they've started with a firm, rigorous, constructive, but conservative approach, and they're slowly marching forward in what they're allowing. And I think Hong Kong will become a virtual asset hub. We're talking about ETFs, we're talking about custody by traditional finance houses. We're moving on beyond, can you set up a platform to buy and trade Bitcoin, to a more detailed, sophisticated financial market in virtual assets. But the starting point, and every regulator in Hong Kong will say this, is they need to enable retail investors to invest safely. And that's why they're taking such a rigorous and conservative approach to start with.
Are traditional methods of asset recovery outmoded in the age of crypto?
I think that's a very good question.
Because people tell me the fundamentals of how, for example, if you look in AML investigation versus how you conduct a PEP, politically exposed person investigation, it's essentially the same. Only one that focuses on the money, the other the person on the focuses on the person, but many of the intermediate analytical steps are the same. Does that apply to crypto as well, or are we in a different age? Is this a different ball game?
It can apply in a way
where the old rules don't fully apply.
Yeah, I think it can apply in a way. The easy answer to your first question as to whether the old asset tracing rules are outdated, the easy answer is yes, because it takes so long to go to court and get an injunction and then defend the injunction, get a disclosure order and then get disclosure from the exchanges. I think those methodologies are, I'd say they're creaking a bit. I say the easy answer is yes, because what's the alternative? Prevention is always better than cure. So looking at PEPs, looking at AML, transaction monitoring is a much more effective way of preventing money laundering or preventing fraud in a banking system. But what we're talking about is, what do you do when it's happened? And what is the alternative to having a judge scrutinize your case? Well, the possible alternative is you have a much easier way of freezing assets, in which innocent people have their assets frozen. There are methodologies in French-speaking countries, France, Monaco, Luxembourg, where you can go to a notary and present your case to a notary, and they sign off on an asset freeze, and it's temporary, just like an injunction is, but that hasn't gone to a judge. It's called a césure, and I'm not saying that is a bad system or that people suffer as a result, but the more you remove checks and balances, the more you will then swing the other way, and innocent people will be affected. So I don't want to say it is outdated, because I think we'd have to come up with a way of making it more efficient while still maintaining the checks and balances.
I know the common law tradition they are not sanguine on granting TROs, temporary restraining orders, injunctions, because this brings up the whole other issue of ex parte communications with judges, right? Where one side is present with a judge and the other isn't, and that goes to the roots of fundamental fairness. That's why they're less inclined to grant such orders. But yeah, sometimes it's life or death. Sometimes it's make or break, and the decision has to be taken immediately. So they serve a purpose. But yeah, it's good. It's good that mechanism exists, even though the other side might be irked that the judge met with one side without them being present. So
yeah, and the same applies to letters of no consent issued by the Hong Kong police, and whether they should be issued and what they do. The advantage of letters of no consent for victims is that as long as the police are prepared to do it, it's much cheaper. You're not in control of it, but it's much cheaper and could be much quicker than building a case, going to court, pleading in front of the judge, and then serving that on the bank or the exchange.
Is it just me, or are the rules of the game rigged in favor of the financial world? I mean, maybe here we need to be cautious about what we're saying, because this is Hong Kong's bread and butter.
Yeah, the financial world is not. The legal teams in the major banks and traditional finance houses have a not insignificant burden to meet regulatory requests and inquiries and investigations.
Of course, they have their own pressures too. Yeah, we must acknowledge that. Yeah,
I think with the world of cryptocurrencies, the issue that we've had is that we don't know who is regulating the crypto world and how. And it was really interesting to see after 2017, I'd say 2017 to 2019, there was a definite shift in focus where you heard people calling for constructive regulation in the cryptocurrency world. And that's because there were legitimate players in that industry who wanted to show that they were legitimate and separate themselves from the very bad reputation that cryptocurrency is a method for fraud. And look, it can be what we see in all our cybersecurity cases. When there's a ransomware attack, there is always a demand for payment in cryptocurrency, and there's structural reasons for that. But not every transaction in cryptocurrency is a fraudulent one.
You know, it's interesting because for the longest time, the Hong Kong Monetary Authority's position was, we do not regard crypto as a currency, but these are digital assets that people trade at their own peril. And for the longest time, that was the position they maintained. But you know what struck me as weird was, okay, if they're digital commodities, then, but yet AMLO, the anti-money laundering ordinance, which came out in 2011, which consolidated the different bits and pieces of AML legislation that existed in the territory before that, factored in digital assets. Yet you wouldn't apply AML rules to other currencies, to other commodities. But here you're saying it's not a currency, it's commodity, but you wouldn't apply AML rules to other commodities. Do you see that, the twisted pretzel logic that regulators can get themselves into?
I think you would apply AML rules to commodities if they would.
I can see how sanctions rules would be applied.
If it's the proceeds of a crime and you can prove that it's proceeds of crime, then it should be frozen and reported. Now, that is traditionally fiat or cash assets, but it can apply more broadly than that. I think this is where...
Does it say equivalent value in the statute? I'm not sure if it does. Or other assets of equivalent value. I can see how it can be applied more expansively.
Yes.
And they probably should, because otherwise that leaves criminals with a major loophole.
Yes, and that's where I think some of the exchanges are pretty compliant. Some of the exchanges need to put in place procedures that recognize that AML legislation applies to them. If they're put on notice that there are the proceeds of crime passing through their exchange, they are under an obligation under the AML ordinance to investigate that and report it. We've had difficulty with some of the exchanges because, and this is going back a couple of years, but the exchanges have told us that they just don't have manpower to process all of the lawyers' letters that they receive. But that's not an excuse, and I think it's a fairly dangerous position for exchanges to be taking. They will, I think, step up, and certainly if they're getting licensed by the SFC, they will need to show that they have appropriate AML procedures in place in order to get past stage one, let alone get their formal license in place after a stage 2 review.
I've attended my fair share of AML and financial crime and compliance events writ large over the years. And something that, if not at every event, every other event, is that people talk about the intersection between cybercrime and money laundering. I haven't heard a concrete definition of it. That everyone seems to have viewed it slightly differently. Is there an intersection between financial crime, between money laundering and cybercrime, and if so, what is it? How would you describe it? What are its traits? What are its tendencies? What are its hallmarks, red flags? Does such a connection exist, or should we just look at cybercrime, the internet, as the instrumentality used to perpetrate said crime?
I think there is an intersection, and I would describe the intersection as money mules, and Hong Kong has, I think, an issue with this that the police are trying to resolve, but it has been hard to set up bank accounts in Hong Kong, and so people that have bank accounts have been selling the use of those bank accounts, and these are, we call them money mules, but they get paid for money transacting through their account, and effectively that's washing the proceeds, whether it's a traditional fraud or whether it's the off-ramped proceeds of a ransomware attack that have been converted from cryptocurrencies into fiat, or whether it's people using their cryptocurrency exchange accounts, or allowing their cryptocurrency exchange accounts to be used to transact funds as part of a bigger group for a payment. I think that's really the intersection, is the layering into the financial institution and then getting it back out of the fraud into the real world. But I think what interested me more about your question was your very last point, which was essentially, what is cybercrime? Is it something that's done in the computer? Is it something done in the ether? And legislative bodies around the world are struggling with this, which is why you're seeing online harms legislation being enacted around the world to make criminal acts in the real world that lead to harm in the online world. So, for example, somebody bullying in the Fortnite game, or somebody who is experiencing real world harms as a result of something that's done online. And this is important because as we move towards a more augmented reality, we will see more and more people living in the online world, and not just in computer games, but in an augmented world. So I think that, to me, is an interesting issue that we need to look at, is what exactly is a cybercrime? Because a cyber is just a crime that uses some form of technology.
Your point about augmented reality, VR, I mean, it's germane because it implicates the other perennial question that people have had for a while now, which is, what are one's rights in the realm of Web3 that everyone keeps harping about, but people don't know what to expect? I mean, there was a case of literal sexual assault in the virtual world, and someone's dignity was violated, assailed, and then the question is, what redress does the victim have, if any? Because, I mean, in an earlier age, they would have said, you don't like how you're being treated, then stay off. I mean, it's not like the physical world where you have no option of engagement or interaction. You have to live in the physical world. You don't have to be online, at least not to that extent. But some might say that reeks of blaming the victim. But again, it comes down to what are your rights in an augmented reality, and should they necessarily parallel and mimic your rights in the physical world? Is that even attainable? Is that even enforceable?
This goes back, AJ, to a point that I made earlier, is that calling yourself a crypto expert or a Web3 expert is, I think, it's just not possible, actually, because kind
of like a best efforts clause, very dangerous.
Well, the things we're talking about now relate to criminal law, and I'm not a criminal lawyer. I could give you my thoughts on somewhere that you might think about drawing the boundary, but what if the boundary is breached through no fault of your own? For example, there was a report a couple of weeks ago about a financial institution that might have been a company, rather than a financial institution, but the financial team of that company transferred a lot of money, and I mean an awful lot of money, because they had a video chat with deepfake videos of the CEO and other senior people in the organization sent to them, asking them to transfer money. Now, what you normally put in place is a process whereby if you are asked to transfer funds to a different account, you should pick up the telephone and you should call those people. But the victim here presumably assumed that they were speaking to these people or had done what they needed to do, because they were sent deepfake videos of a conversation where they were being asked to do that by people that they thought were their bosses. And in that situation, the veil wasn't pierced by the person entering the augmented world. The augmented world came to them. Like I say, I'm not a criminal lawyer, so I wouldn't profess to say I know any of the answers about how we deal with real online harms. I just think it's a very interesting and complex question that needs to be addressed.
I don't think this matter is going to be resolved anytime soon. Certainly it's going to be a question that's going to perplex far greater minds than ours for the remainder of this decade. But thankfully, organizations like CFAAR exist. And tell us about the initiatives you've currently got ongoing and the projects you're working on with CFAAR.
CFAAR was launched in the UK in 2021, and in Hong Kong we were looking at launching at the same time, but we still had the COVID restrictions though, and I think November 2021 autumn 2021 they were coming back with a bit of a vengeance, and so we decided it was best not to launch then. But we launched in September 2022, having put quite a lot of work into it throughout that year. And we had a launch event where we did a round table and asked people to essentially brainstorm at their table how much they had seen crypto fraud, what their involvement was in it, whether they knew how to respond to it. We have not had lots of events, and I think that's very fair to say. The committee is an organization of people that have jobs. We don't have a paid administration. And so what we want to do is we want to ensure that the events that we run are of a high standard instead of doing them all the time. And we had an excellent session with Julia Lung from the SFC in June last year, where she talked about the virtual asset trading platform regulations. And she was very open and honest about what the SFC is trying to achieve. And both the quality of the speaker, but also the quality of the audience showed that we were doing something right. We then had another session later last year on blockchain audit and what you can achieve. And we had a committee meeting on the 26th of February. And we're looking at another event in the next few months. But again, we want it to be a problem-solving event where we encourage people to come up with ideas for solving one of a number of issues related to crypto fraud. So there will be more on that coming out. But in our discussion, we were very clear that we don't just want this to be another talk where we don't share anything new, and we want participation from the audience, because Hong Kong has, as I said earlier, it has a very sophisticated crypto and virtual asset ecosystem, and it would be misplaced of us on CFAAR to think that the committee members are the only people that have anything valuable to share. I think it's the opposite. Actually, we should be learning from each other. So watch out for that in the coming months.
Definitely do that. We do have a sophisticated crypto asset ecosystem, certainly in terms of the legal profession. It's interesting because if I were to juxtapose Hong Kong with Dubai, what I find is there's a frenzy of activity in the crypto asset space in Dubai. A lot of cash flooding into that town. But the critique I hear is that even when people go to your magic circle, your white shoe American, this critique is true. The Anglo-American law firms in general in Dubai, the lawyers there I don't think they're as savvy on crypto as the ones in Hong Kong and Singapore. Just my opinion. That's something that's really lacking there yet, because they've made themselves amenable to the interests of the industry by giving them the first world's first virtual asset regulatory authority. That's where the money's flooding, and maybe that's inevitable, that the business takes place first, and then you figure out the rules and regs. That's the typical pattern with many sectors and many industries. But yeah, I mean, my opinion is the legal talent there. I mean, this isn't just me bragging as a Hong Kong boy. The legal talent there just is not commensurate with the level of transactional activity going on there in the crypto space. Just my opinion, but I'd be keen to hear your thoughts.
I think there's some very good lawyers in the Middle East,
but it's a pretty mixed bag, though. It isn't the same degree of consistency as you get with this town, but maybe that's because we're a more mature legal market.
Well, and that actually is what I was going to move on to. I mean, CFAAR launched in the Middle East last June, and it was incredibly well attended. I think this comes back to the dichotomy in the virtual asset world between people that want a permissive regime and people that want a sophisticated, heavily regulated regime. And then there's a whole spectrum of people within that. But if you have a jurisdiction that is permissive, it will gain a lot of interest. A lot of companies will move there and will get licensed. And I don't want to criticize licenses given by Middle Eastern authorities. But if there is a criticism,
they are moving the industry forward. I have to give them credit for that.
Yeah. They are indeed. They are, and they have some licensing process. The criticism that the SFC has received about its virtual asset trading platform regulations is that to become a licensed exchange by the SFC is too onerous, it's too rigorous, it's too long, and it's too expensive. But there's a reason for that, and so if you want to get a license from the SFC, you will have to comply with a lot of measures that are put in place with traditional finance. If you want to be licensed somewhere else, then you comply with the measures that are put in place in those jurisdictions. But Hong Kong has for a very long time been a global financial hub. And so we have the expertise here. We have a regulator that is used to regulating financial products. It will necessarily be a rigorous process to get regulated here if you want to get regulated by the financial regulator in Hong Kong.
Yeah, it's interesting because the other critique is Singapore is no bed of roses. You know, everything's on provisional there with people. Everyone's on provisional. Nothing much was getting approved for the longest time. And, you know, it's interesting, again, you mentioned Julia Lung, because I think some years ago, this is around about 06, 07, she might still have been with the SFC, but it was either her or one of her colleagues speaking at a Hong Kong Securities Institute event. And she said, well, people in the hedge fund, you know, draw parallels with the hedge fund regulation. People in the hedge fund space were saying, well, Singapore doesn't expect this much of us. And her point was, okay, fine. Go set up shop in Singapore. Hong Kong has certain standards. And that served us well come the global financial crisis. There is something to be said for having robust regulation, that gives the market confidence. But at VARA, I mean, it's like they're really going light touch. And the global financial crisis, I think, changed the minds of many libertarians even, which was Wall Street can't regulate itself. That all too often self-regulation means no regulation.
I was going to say organizations like CFAAR, but anybody that is flagging risk in virtual asset investment is doing a service to the public. It is a varied industry, and some of the exchanges and token issuers are completely legitimate, and we act for a number of them. And then there are exchanges and token issuers that either are a scam exchange or a rug pull token, and it's very hard for people to understand what the difference is. And what I would say to people is, I'm not going to criticize UAE licenses at all, but if they're going to trade with through a platform or even an asset manager that focuses on virtual assets, they should do their research. There's a phrase in the crypto world, DYOR, do your own research. And that actually is incredibly important because it is such a varied industry that people should be properly researching the people with whom they're interacting, what their credentials are, what track record they have. That will get easier as licenses are handed out, but then they need to look at where those licenses are coming from and understand what that means. The job of a regulator is not to stop fraud altogether, because they can't. It's to minimize the incidence of fraud and minimize the impact of frauds that happen. So if you're trading cryptocurrency through an exchange that's licensed by the SFC, you know that there will be rigor that's gone through that process. I think the difficulty is that people have been burnt and they don't draw the distinction between scandals that happen and why they happen. So if you look back at JPEX, for example, last year, there was a lot of criticism of the SFC for not being more vocal about JPEX and the fact that it might be a fraud. And just for the record, it has not been proven that JPEX is a fraud. I'm not acting for them. I just want to be clear about the fact that there's no proof yet that JPEX is a fraud. But the SFC said actually for quite a long time that the investing public should be wary of them because they were put on their alert list. There was criticism from some members of the Legislative Council that the SFC wasn't doing enough to alert people to a potential fraud. And what's happened as a result is that the SFC has now published all applicants for a virtual asset trading platform license. And to be clear, the SFC does not do that in other industries. It's something new that has arisen because of the criticism that it received for not being more vocal. And you'll see very regular press releases by the SFC about potential fraudulent trading platforms. So the SFC is going out of its way actually to tell people of the dangers of investing in certain platforms, but people need to draw a distinction between a failure of a platform and why that happened. Actually, the reason that JPEX was called out was because the SFC finally had its powers to regulate virtual asset trading platforms and became a lot more vocal and involved the police in the JPEX issues. And had the regulations not been in place, then fraudulent platforms might still exist that are now being stopped. So just because a crypto scandal occurs doesn't mean that that's bad for the jurisdiction. What it is that the regulations bedding in.
Just want to shift gears. In early February, the Office of the Privacy Commissioner raided the offices of WorldCoin. Now, you mentioned in a LinkedIn post several weeks ago, the PCPD expressed concerns about WorldCoin's collection and storage of iris scans in exchange for a WorldCoin token. You also said that it was a clear example of an increasing intersection of personal data protection principles and digital assets. Could you elaborate? I mean, these intersections really fascinate me. I find them fascinating because of the issues that they give rise to and the clash potentially between different areas of law.
With WorldCoin, it was an interesting concept. What they were doing was scanning people's retinas with basically a big silver ball. And in exchange for your retina being scanned, giving out WorldCoin tokens. Now, the company has said that it didn't store that, it used it to train its system, and then it deleted the biometric data. I was at Token 2049 in Singapore in September last year. The queue for the WorldCoin stand was, it went out half the room. It was an incredibly long queue because people were being offered free WorldCoin tokens. And all they had to do was scan their retina. This, again, it's similar to what we were just saying about cryptocurrencies, is people need to understand what they're getting into. And with personal data, a lot of the personal data regimes are based on consent and informed consent. Now, the intersection between personal data protection and digital assets is really interesting because privacy has been at the core of the virtual asset world for a very long time. And I find that ironic because, as I said earlier, unless you're talking about a privacy coin like Monero, which is now being delisted from a number of exchanges, unless you're talking about a privacy coin, cryptocurrencies are actually some of the most transparent assets in the world. And yet you see some crypto evangelists calling for privacy in their ownership. And there have been a number of tumblers that have been sanctioned by the US authorities for essentially enabling money laundering. Now, why, for example, Tornado Cash was sanctioned, my understanding was that they were actually dealing with individuals who were sanctioned. Now, I don't know whether that is true. I haven't acted on that case. But what resulted from the sanctioning of Tornado Cash was a debate about whether privacy should be permitted in digital assets. And I find that incredibly ironic because it is one of the most transparent asset classes in the world. So should people be entitled to privacy? And what does that mean? The transactions on a blockchain, if it's a public blockchain, are transparent. But your ownership of the specific tokens is not, because it uses public keys, and you don't necessarily know what those public keys are. But blockchain tracers are increasingly being able to say, I know from the work that we've done previously that this wallet address is an exchange with this person, or this wallet address is a private wallet owned by this person. So because it's such a transparent asset class, even the ownership of specific tokens is being eroded as blockchain tracers are becoming more sophisticated. You then get on to questions of what personal data should be permitted in virtual assets. So if we shift gear a little bit, what about NFTs? NFTs are virtual assets. What if an NFT actually links to an image of an individual and you then share that NFT? Are you sharing personal data of an individual because they can be recognizable to someone? So these are all questions that have not yet been addressed, but I think they're going to come up, especially as NFT marketplaces are. I think the next big wave in Hong Kong is pure NFT marketplaces. So on the one side, you'll have more sophisticated products like ETFs and hopefully derivatives being launched. On the other hand, you'll see an increase in NFT marketplaces. Now, with all of that, ownership rights, personal data, by being able to identify people, I think there'll be an increasing intersection of personal data protection and the digital asset world.
Certainly, the cutting edges of the law have yet to be defined. That certainly makes it an interesting space to watch. Now, in the same LinkedIn post, you added that it was further proof that the Privacy Commissioner is flexing her existing powers even before the amendments to the Personal Data Privacy Ordinance are expected later this year. What do you expect to see as the contours of those amendments? Well, what shape do you see those amendments taking, and what will it mean for the financial world and multinational corporations more generally? And again, this is going on against the backdrop of greater data sharing initiative across the Pearl River Delta. So, number of interesting things going on.
I would love to say that I'm an incredible prophet on these issues and that I have some secret insight that other people don't. But actually, this is pretty transparent. What happened was in January 2020, there were some proposed legislative amendments to the Personal Data Privacy Commission. And these included mandatory data breach and notification mechanisms, relying on a threshold of a real risk of significant harm, with notifications being made as soon as possible, and in any case, not within no more than 5 business days, requiring a data retention period policy, i.e. companies need to have a policy about how long they will contain data rather than simply as long as is necessary. Giving the Privacy Commissioner direct fining powers. At the moment, the Privacy Commissioner is, if you take out doxing and direct marketing, if there is, for example, a data breach, there's no direct fining power. What the Privacy Commissioner can do is investigate, issue an enforcement notice requiring certain steps to be taken. And then if the enforcement notice is breached, then there can be a fine of, the first fine is, I think, $50,000 Hong Kong dollars. They also want to regulate data processors, because at the moment, there's no direct regulation of data processors, only data users, or as they're called in other words, data controllers. In 2020, they looked at changing the definition of personal data from relying on an identified person to an identifiable person. And the final thing that they looked at was doxing, i.e. sharing of other people's personal data without their consent. What actually happened as a direct result of the protests in 2019 was that LegCo focused on the final point, doxing, and implemented in late 2021 the new criminal offences related to doxing. And they did not spend their time working on all the other amendments. Now what has happened is that the Privacy Commissioner has said that she is still working on these amendments. And on the 19th of February, there was a LegCo paper that talked about the current directions of proposed amendments to the PDPO that the Privacy Commissioner's office is working on with the government. And they include mandatory data breach notifications, data retention period policy, administrative fine, and regulating data processes directly. So there's no mention of changing the definition of personal data. I don't know whether that might be subsumed within this, but these are all the things that the Privacy Commissioner talked about in 2020. So we expect there to be an updating of the Personal Data Privacy Ordinance to include what is seen quite regularly in other legislation around the world. And the administrative fines is quite interesting, because how that will work is that the Privacy Commissioner's office will issue a proposed fine, and then the investigatee will have the ability to challenge that. And that's what you see with the SFC. They issue a notice of proposed disciplinary action, and the body being sanctioned has an ability to challenge that if they want to. And then there is a notice of disciplinary action. So it's going to be a similar process here, where the PCPD can issue a direct administrative fine for a breach, for example, of failure to protect personal data. Instead of issuing an enforcement notice and saying you didn't do enough, they could issue a direct fine. And what they're looking at is the level at which that fine will be placed and whether it can be based on turnover of the company. So, like I said, I'd love to say that I'm some diviner, but this is all public. We were expecting to see these changes this year. There was a question from LegCo about whether the changes would be implemented, or we would at least see the amended laws this year, and there was no direct response to that question. What the response to the question was, we're working with the government and we'll provide you with the draft legislation when it's available. So we don't know when the new legislation will be published. We're hoping later this year. The reason that I say that is combined with the Privacy Commissioner flexing her existing powers is, if you look at the Privacy Commissioner's investigation reports, in a period of 1 year and 1 day, from late 2022 to 2023, there were 4 investigation reports specifically relating to data breaches. And then in June 2023, Privacy Commissioner issued updated guidance on data breach handling. So it's obvious that the Privacy Commissioner's office is getting ready for a situation where mandatory data breaches will be required. The LegCo paper was quite interesting, actually, because it also went on to say how much enforcement action the Privacy Commissioner's office had engaged in on doxing. And from October 21 to the end of October 23, the PCBD initiated criminal investigations into 228 doxing cases and made 39 arrests. It also issued more than 1,800 cessation notices to 41 online platforms, asking them to remove almost 27,000 doxing messages. And there was an overall compliance rate exceeding 95%. So I take from that quite an interesting point, which is that in around 90 cases, the platforms didn't comply with the takedown notice. So there was a roughly 5% non-compliance rate. We've acted for some platforms that don't comply with takedown notices, and they have some good reasons for doing that. But what I found interesting is the number of enforcement actions that PCBD has been taking on doxing and forcing companies to take down notices. And that, I think, is combined with the investigation reports about data breaches and then the new powers that are going to come into effect at some point in the next few years. And that's why I say there's a flexing of muscles here. The Privacy Commissioner has moved from a mostly informative and investigative authority to one that is trying to take enforcement action. And I think we will see more of that, but hopefully we get the amendments, the clarity on what the amendments are. As somebody who advises international companies on data compliance, it's quite hard to say that Hong Kong has an up-to-date legislation. I don't like calling for more regulation, but if we're going to have some regulation and the legislation is going to change, it would be good to know what that is so that companies can put in place proper governance mechanisms, because we've already got a much more sophisticated legislation over the northern boundary with the Personal Information Protection Law of mainland China. So companies need to plan their data governance. So it would be good to know what the amendments will be.
Certainly sounds as though things are going to get more punitive. Maybe this is a bit of naivete on my part, but we do live in a world that's still largely regulated by New York, London, and Brussels, and I can't help but wonder to what extent are the amendments to the PDPO somewhat a response to developments in the GDR space in Europe?
I mean, they are. The 2020 paper said that the Privacy Commissioner's office had looked at developments, including European GDPR. So they are. The question is how much they will mimic them. What we're seeing across Asia is new legislation being put in place specifically to tackle personal data. So you've got the Thai Personal Data Protection Act, which came into effect, which is replicates some aspects of GDPR. You've got the Personal Information Protection Law in mainland China. India is passing a data protection law. Indonesia, I think, has just passed one as well.
I think the Indian one was passed in October of last year.
Yeah, so you're seeing much more sophisticated personal data protection regimes coming into effect across the region. Hong Kong is not there yet. Malaysia as well has a relatively laissez-faire law when it comes to data breaches. But across the region, we're seeing mandatory personal data breach reporting in quite short timeframes as well. So it is where regulators are going. If you take the side of a corporation that's handling personal data, you might say that it's extreme. If you take the side of data subjects, you might say that they need protection. What we need is certainty, and that's why I say I look forward to seeing what the legislative amendments will be.
Yeah. As we finish up, what advice would you give students, young law students or young lawyers seeking to enter this space? That it's exciting, it's potentially lucrative, certainly engaging. That they could learn a lot and contribute to something that's really going to define the payment and economic infrastructure in the 21st century. What advice would you give to them as the field that as technology increasingly encroaches on law, on the legal profession? Or is it the other way around? What advice would you give them?
I think it is. I think it's the other way around. The legal profession is increasingly encroaching on new technologies, but I think that's right, and it should be happening. The advice I would give is not necessarily to find something that they like doing now. Going through university, you have to enjoy the topics that you're studying, unless they're mandatory topics, in which case you just have to do them. But it helps to enjoy the topics. And so if they can find a topic that they want to do a dissertation on, it should be one that they're interested in. However, thinking that that topic is going to apply in 10 years' time, I just don't think is the right way of looking at it. They should be open to changing. They should find what discipline they like, whether it's doing contentious work or transactional work, and they should get very good at what they do. Find a job, find discipline, get very well practiced in that discipline, and then apply that discipline to new areas. And the reason I say that is going right back to something I said at the start, which is that the Satoshi white paper didn't exist until I was in Hong Kong. And by that point, I was already 3.5 years qualified into a litigation team, a finance litigation team. And so you're not constricted. As long as you're open, you're good at what you do, you can then pivot and apply that. I agree with you, AJ, that you can't say that you're an expert in a whole sphere. But know what you're good at and then apply that to new areas. That's, I think, the advice that I would give, because if you focus on something that you think you want to do now, that may have completely changed. We're already seeing a commoditization of legal opinions on whether tokens are utility tokens, so that the tokens can get listed on exchanges. And so there will be less and less money doing that unless it's done on a very commoditized basis. The technology of the future, we don't even know about now. You see, with electric vehicles, there's a pivot now towards hydrogen away from electric. So I just don't think it's. I don't think it would be necessarily healthy to go in and say, I want to focus on the law on NFTs, and I will do that as my career. I think it's fine to do that as a dissertation now, and to be interested in that sphere. But in 5 years' time, 10 years' time, there will be new things that have come around that will be much more interesting, and we just don't know what those are yet.
Yeah. I mean, the future has yet to be discovered. Now, fortunately, it will be the young people in the profession that will get to live to see those changes, and I believe by that point they will be sufficient seniority in the profession to hopefully drive some of those changes, both the legal and policy level.
Yeah, and AJ, I think if I were doing it, I'm fascinated by the use of AI in increasingly good robotics and the law on personality. Will robots be granted a legal personality? That I think is a fascinating topic, but we're not at the moment. It's still sci-fi, but it won't be long until it becomes a real live issue.
And some of the literature, fictional as it is, paints a pretty bleak picture, pretty dystopian in its in what it foresees. But let's remain hopeful. Well, thank you so much for your time, Jonathan.
Thank you very much for having me.
Let's do it again. And to our listeners, thank you. Until next time.